What's up, everybody? It's Peter Tragos, the lawyer you know, and on this channel, we break down the trials and cases you care most about so you can understand how the American civil and criminal justice system works. And we try to make sure you understand what your rights are in every situation, which is why we try to walk you through the entire legal process while also answering your insightful questions along the way. And while it's not legal advice, it's always exciting. So buckle up for another episode of The Lawyer You Know. What's up, everybody? Another day here in the mountains on vacation, chilling. And it's, if you ask me, a perfect day of vacation. We'll be hanging out with family. We got golf on the agenda this afternoon. It's like mid-50s and sunny here. Our course where my parents' place is at is frozen under, or frozen over, or whatever it may be. So we're having to kick over to a different course, which is fun because I've never played that other course. So that's going to be awesome. It's 50 degrees. I'm not playing with my actual clubs. I've got an old set I keep up here. So the over-under is probably more like 85 today rather than the normal 80-ish. So that's the over-under today. If you want to follow along, I'll probably post some pictures on Instagram at Tragos Law if you want to follow us there. But it's a beautiful day. And then after golf, we, of course, have the Florida State bowl game tonight. If you don't have a team and you don't care about a team, root for Florida State against Oklahoma. We need some revenge after they beat us a couple years ago back-to-back. And then after that, we got Thursday night football. So it's going to be just an amazing, relaxing day here in the mountains. Hopefully you guys are also having an amazing day as people come on. You know what we're talking about today. It's Sarah Boone. We discussed her lawyer's motion to withdraw. We discussed how under certain circumstances, the judge would just flat out say no, because we're not going to leave a criminal client looking at life in prison, hang her out to dry, regardless of what you think of her. We're not going to do that in Florida. I've seen judges reject motion to withdraws and deny motion to withdraws over and over again. But we said if Sarah Boone wants out and the lawyer wants out, there's almost no way the judge can allow this to go forward and have these two who don't want to work together continue to work together when it's this serious of a case. But on the other side, we've got to balance getting this case to trial for the victims and their families to get justice. So we're here with answers. We've got the docket. We'll explain what it means. We'll explain what the decision the court made and why. We will also read through the letters that Sarah Boone has sent to the judge and a letter she has sent to her lawyer and explain how that works into this process as well. We've had a lull in subscribers here, toward the end of the year, a little less content. So that's, it is what it is. If you guys haven't subscribed yet, hit that subscribe button. We're trying to push out towards 175K. So tell your friends if they haven't subscribed. 50% of people that watch don't subscribe, which is cool. It's free to subscribe. You should subscribe and like the video, of course. But we also have Sydney Alberts out here gifting memberships. Sydney, thank you so much for that. I saw a bunch of people got memberships today. Thanking Sydney for that. That's cool. If you guys want to join the membership crew, we do some members only chats and videos throughout the year and some other, exclusive merch and stuff like that, which is cool. Kathleen always roots for Florida State, which is amazing. But let's get to it. Okay. Let's get to Sarah Boone and what happened. So the first thing I'm going to share here with you is the docket. We know that her lawyer filed a motion to withdraw, meaning he does not want to represent Sarah Boone. We went through that motion to withdraw, and we explained how it made some weird references to his family and how he could not represent her anymore. And if we look at the bottom of this, there was a status hearing on 12/22. And it seems from everything I've read and reviewed in this case that the defense lawyer did not show up. That is not a good look. And what did the court do? She reset the hearing for 12/27, instead of 3 days before Christmas. Now it's 2 days after Christmas, with a mandatory appearance by the defense attorney. We know that on 12/27, The judge also here, you can see on the court minutes that's been put here in the docket, the motion to withdraw was also heard on the 27th. And you can see in the court minutes right in the middle of this snapshot that the comments say, status hearing held, defendant did not ask the court to remove the attorney. When you have a court-appointed case and you have a defendant that does not want to remove the attorney, regardless, almost regardless, now if there's threats being made or if the attorney tells the court that the defendant wants to commit fraud on the court or commit a crime or he's got to withdraw because he's going to be in furtherance of a crime or something like that, then you will see the court grant that motion. However, in this case, very clearly the court denied the defense attorney's motion to withdraw without prejudice. And we know what that means at this point. If you've been following along other cases, especially Depp v. Heard, and even Kyle Rittenhouse when they were asking for a mistrial with prejudice, meaning the state can't refile or retry the case. This is without prejudice, meaning if more stuff happens and this attorney thinks he needs to add to the record as to why he needs to not be Ms. Boone's attorney, and it is necessary for him to withdraw, he can refile. He can ask this court again to allow him to withdraw from being her attorney. So it's denied without prejudice. That's what we learned there. Next, the court, right above the denial of the motion to withdraw, said the defense attorney, she's ordering the defense attorney to coordinate a meeting with the defendant, Sarah Boone, prior to 117-23. What is 117-23? If we look up a couple entries, the pre-trial conference, which is 2 weeks before the actual trial date on January 30th. We will be covering that here. You know that. So what does all this mean? What does this look like? What does this indicate? So first, let's talk about what happens at a pretrial conference. There are different kinds of pretrials, especially in criminal cases. There's status conferences, there are plea deals, there's all sorts of things that happen at pretrial conferences. However, the pretrial conference 2 weeks before the trial date, that is the conference where you get a lot of your trial details ironed out. How many strikes you're going to agree to, if you're going to agree to any less jurors, if you're going to agree to witnesses by Zoom, how many days is it going to take, how many witnesses does each side intend to call, how long do you expect your jury selection to be, how many days do you think the entire case is going to take, what do you need for the defendant if she's in custody, like in this case, is she going to need certain clothes or whatever, what do we agree with, what do we not agree with, those are all of the things that take place at the pretrial conference or before between the parties or between the lawyers. Well, the fact that the court has to order this attorney to meet with Sarah Boone prior to this pretrial conference is concerning to me. All of these things are concerning to me when we talk about appellate issues. Because if this lawyer is not working on the case or not meeting with his client who's being tried for murder, if they're not even meeting at all on the lawyer's own accord, how is he possibly prepping her defense? And I don't want to hear, oh, maybe he thinks she did it or she admitted she did or anything. He's a criminal defense lawyer. He's a court-appointed lawyer in this case. He handles all sorts of criminal defense cases, and criminal defense attorneys, and I know, they do not withdraw because they think their client might have done it, or even if their client has admitted doing it, because still holding the state to their burden, making sure the state can prove it, is part of being a criminal defense attorney in these types of situations. Some people don't agree with that, and I understand, and I'm here for that conversation. I'm here if we want to discuss that and think we should have a different system where if somebody admits it, they shouldn't be able to go to trial. Let's talk about it, right? We can talk about that kind of stuff. But as it sits right now in the laws in our state and in our country, criminal defense attorneys like, I think it's Bankowitz is his name, I can't remember his name, deal with those issues. That's not a reason to withdraw. And when we talk about a denial for a motion to withdraw and forcing this attorney to show up to court and forcing this attorney to meet with and talk to his client prior to the pretrial, that's not a good look for this lawyer. And if you look, there have been other reports in his past of clients saying he does not communicate appropriately with them. So that's problematic as well. Yeah, Azam said, let's talk about that one day. Yeah, be happy to. Okay, so we've seen all this, right? We've seen what the issues are. Now let's try to get an indication as to what Sarah Boone felt was going on in this case. First, we're going to read a letter. This may be a little difficult because you may not be able to see it perfectly. I'm going to read it to you, so don't fret. This is a letter that Sarah Boone wrote in October of this year to her lawyer, Mr. Bankowitz. And again, like I said, if you can't see it, I will read it, so don't worry about it. All right. Mr. Bankowitz, I zoomed in here. 10/3/22, Frank Bankowitz. Mr. Bankowitz, I am writing in regards to not hearing from you and becoming very concerned after receiving no response to any of my daily calls or from the letters I've sent. As of today, October 3rd, you have been my court-appointed attorney for almost 3 months, 12 weeks, 84 days, and we've only spoken 3 times. 7/14/22, video introduction. 8/2/22, video update. 8/22/22, visit in person, 90 minutes. So that's 90, 105, 120 minutes total, about 2 hours. That is enough to do basically nothing in a murder case. I have written 2 letters in the meantime. Also, my most recent I sent on 9/12/22 with no response. So they met in August. She wrote a letter in September with no response. She's writing a letter in October that she gets no response to. I'm aware of the difficulties you're having communicating with me, video, phone, letter, in person, especially via phone, which to me is the simplest form of doing so, even if just for a brief update, which only takes minutes. I believed by you giving me your personal cell number, you are going to answer. That, to me, this is not an unfair request from Sarah Boone. If he gave her his personal cell number and he said to call her, he is her lawyer, I would at least know all is well and have a better understanding of the status of some things and what to plan or what I may need to work on. With no, and we're going to pop out here to the next letter, or next page, I should say. This is the letter to Bankowitz. This is the letter to her current lawyer. With no communication, it makes it very difficult on my end, drawn out and painful. Please figure out whatever necessary for my phone calls to be answered, which you will be reimbursed for when you submit your costs. That's fair for her to say. That is absolutely fair for her to say. There's nothing unfair in this letter so far. It feels at this rate of communication and meetings, and you just coming on board, not having all of my discovery to go over, still on top of everything else to be done, and depth, how much longer am I really going to be here, added to 32 months already? Well, he's not going to know that, but it could be a lot longer, especially if we communicate, however you eventually do, only one time a month, if that. As for all of the month of September, I know nothing from not hearing from you. I understand you have other clients, as I am one also, and you've been recuperating from your back. But remember, please, how long I've been here. You are my 6th attorney, not by choice, to everybody in the chat, right? I think some people in the chat would disagree. And the magnitude of my case with not knowing what's going on or where you are, how much harder it is for me. I want to get on with my life, Mr. Bankowitz, and not miss any more time than necessary from my son. I've already missed 4 of his birthdays and spent 3 of my own in here. Please understand. That's brutally sad. I don't care who you are. It's brutally sad to miss 4 of your son's birthdays. No, 2, I am patient, clearly after all the time I've invested, and still smiling and willing to go above and beyond whatever we need to properly and truthfully convey my very convoluted, misunderstood side of everything, which I boldly told you in our meeting last month. I am dedicated, ready to start, and overdue. I am so very grateful, Mr. Bankowitz, for you. All you are doing, have done, and will do. We're in this together. I'm so blessed. The last line just says, you are my attorney. You don't see this part. I'm just going to read it. God has put us together in each other's paths for a reason. I can't wait to see what you and he will do. Praying the 6th time is a charm. Please respond. I await your response. So some things there, okay? Some things that are fair, some things that are not. Asking him to call her back is fair. Understanding he's recuperating from a back injury, that's fair. Saying she has to get out of here, he's not going to be able to get her out of there. That's going to be up to a jury. Somebody said it sounds like she needs a therapist. Well, a lot of criminal defendants do, and a lot of criminal defense attorneys are part-time therapists as we deal with our clients throughout these cases. But when we deal with cases like this, it's not unusual for clients to be nervous, right? We understand that. And a lot of times lay people are a lot more understanding when they believe the person's innocent than when they believe they're guilty. Additionally, we said, well, what if she said she did it? It does not sound like she said she did it. She has explained her side of the story. She has a theory. She thinks she's not guilty. Whether or not he believes that, honestly, whether or not he believes that does not mean he has to withdraw from the case. If she is telling her side of the story, now, if he has evidence that she's lying, he can talk to her about that, and he can tell the judge, we've been over this before in other videos, if he thinks she's going to commit fraud on the court, then he has to tell the judge, and he can't do that. But it doesn't seem like that's happened. And a couple good questions. Ariana, but if you're made to represent a client, I would think he or she wouldn't put 100% into the case. And Ariana, this is a great question. And this is kind of the point of this channel, right? So we can talk together. I have my buddies and my friends and family text me all the time, like, this guy doesn't want to represent her. He's not going to try his hardest. And while that may be true literally and personally in this case, that's wrong. And he took an oath and swore and told the judge and told the court that if he were to be appointed on these cases, he would give it his all. He is not going to half-ass any defense that he gets court appointed to, or he would not be allowed to be the court-appointed attorney in these cases. He has to give it his all, or he shouldn't be a court-appointed lawyer. Court-appointed lawyers get paid. So if anybody that lives in Florida, if he's not working his hardest, he's getting our tax-paying dollars to represent her. Southern Sass. Peter, has anyone ever been through 6 lawyers before that you know of? Yes. I've seen people go through more than that. Now, 6 public defenders / court-appointed lawyers is a lot. Private lawyers, they've been through way more than 6. Leslie Watkins, how can one person go through so many lawyers? What will they do if no one wants to represent her? Can they make a lawyer do it? They can make a lawyer do it to a certain extent, right? They can make a lawyer do it and do his best and put on the defense. But we've already been, I don't want to repeat myself for the 1,000th time. Not that you're asking me to, Leslie. I just feel like I keep repeating myself. He cannot commit fraud. He cannot lie. He cannot ask witnesses to lie. He can't allow his client to lie. He can't perpetuate a fraud on the court or anything like that. But to do his job, cross-examine the state's witnesses, make sure they can prove the case, let her get up and tell her story that it was either an accident or that the victim wanted to do it or put himself in the suitcase or whatever it may be. If they have inconsistent statements, the state can impeach her with those inconsistent statements from the interrogation. That's how it works. Patricia said the video speaks for itself. That's fine. That has nothing to do with this. What we're sitting here right now talking about is not guilt or innocence. It's not even guilt, being guilty or not guilty, right? This is just a right to have counsel, a right to be represented by a lawyer that's going to represent you in your rights. And to me, that's really what this video is about and what this conversation is about. Squab Bob said, often oaths mean very little in the justice system. Folks get tainted from police through judges and lawyers. 100% agree with you, Squab Bob. And that's why we're talking about this, because I think it's important. I think it's really important that this guy does his job, or he shouldn't be a court-appointed lawyer, right? If you want to be a private lawyer, you can reject any case you don't want to take for whatever reason you don't want to take it. That's what I am. I'm a private lawyer. There are certain cases I wouldn't take. That's my prerogative. But I'm also not going to get paid on those cases. If you're a court-appointed lawyer and you accept these cases, you're getting paid on these cases, you have to do the work. It's just like anything else. I don't know this guy. I'm not besmirching his name. I'm saying generally, public defenders have a very difficult job. We've had public defenders on this show before. They have a very difficult job. They don't love every client. They don't believe in every client, but they believe in the defense. They believe in the law. They believe in the Constitution. They believe in their job, and they do their job. It is funny saying squad, Bob Bodie. I agree. Teresa, do we know why lawyer number 6 wants out? Irreconcilable differences. Him and his family cannot go through with this. We did a whole video on it, Teresa. If you can check out that video, we did a whole video on his motion to withdraw. John O'Rourke, is there a difference between prejudice versus non-prejudice? Motion to be removed as an appointed lawyer? Yes. So prejudice would mean he cannot refile it again. This is the judge's final decision. You are not allowed to withdraw from this case. But this was granted or was denied without prejudice, meaning you can try again. You can file another motion to withdraw. If you have more details or if more stuff happens where you feel like you cannot adequately represent this client, then you can try again and I'll give you another chance and maybe I'll change my mind. That's what it means without prejudice. Patricia, welcome to the membership crew. All right. So now we've read Sarah Boone's letter to her lawyer. Let's take a look at a letter she sent to the judge. And again, if it's blurry or too small, I am going to read it, so don't fret. I think this is it. Yes, this is it. Okay, here we go. Judge Wooten. Honorable Judge Wooten, forgive me in advance for having to utilize your invaluable time to ask the current progress of my case. But after not having any form of communication with my attorney appointed by you now after 11 weeks and counting, after sending 4 letters to my attorney appointed by you with no response, and after finally finding an outside resource to inform me of the uneventful, confusing filed documents online by my attorney appointed by you, keep saying appointed by you, I'm still waiting with the perpetual question mark over my head. By the way, this was sent on 11/3. So it says 4 weeks exactly since my last letter. That was the last letter to her attorney. No letters, no video visits, no face-to-face visits, no answered phone calls from my attorney, or even a response from you, Your Honor, regarding one of my letters expressing my legitimate concern of what's going on in my case and where's my attorney. It has now been over 4 months since being appointed another attorney, number 6, and not by my decision, influence, or choice, and almost 3 of the 4 months not hearing from said attorney. Last correspondence 8/22. Why? What is the reason? Why haven't I received a letter? Even a 15-minute video update, anything, even after my pretrial conference on 10/25 is what truly confuses me and nonetheless upsets me in the fact that I was not in attendance so I could know what's going on in my case, especially considered I have not heard from my attorney in 11 weeks and should have been included. Why was I not? This is my case. Was Mr. Bankowitz even there to represent me? I don't know. Anything still. Before we read page 2, I have heard that there was a waiver of appearance that was filed that she didn't sign. In Florida, she should sign that to waive her appearance, especially in felony cases. And if she wants to come to the hearing, she absolutely has a right to. And if she doesn't come to the hearing, the lawyer better let her know what happened in that hearing. So none of these right now are unfair by Sarah Boone that she just wants to be updated in her case. This is her life. And I realize we watch these interrogations and we heard her admit certain things and we think certain things are horrible. And if she gets convicted, she deserves the punishment. But as we're here right now, she is asking for very reasonable updates and she's presumed innocent. So I am a little frustrated by this process for her, and I think this is a legitimate concern. People saying she's insufferable. Sydney, okay, this is a good comment here. If you feel this way, that's understandable. She's insufferable, but she deserves a fair defense and trial. Her feelings in this are valid. Sydney says it a way that I think lay people should understand this process, regardless of what you feel about somebody, which I think Sydney does not feel positively about Sarah Boone. She's being held there. Most criminal defendants that are in custody want to go to their hearings, and you can understand why. It's miserable. You're in the jail cell all day. You got nothing to do. You're bored. All they're thinking about is their case. They're trying to do research on it. They're trying to call people to help them. They're trying to talk to their lawyer. They're consumed with it. It is their only case. When she mentions she understands this lawyer has other cases, she's right. And this is tough. Kaylee says, I feel for her if this is all true. And this is an important point because this could all not be true. But if it wasn't true, you better believe her lawyer would have told the judge that. And I will say, there are other things that put this into context that make me believe her, at least partially. The lawyer didn't show up to a hearing, and the judge had to order his mandatory appearance at a future hearing. That is not great. That is not great. Somebody else by the book said, do we know this is true? Well, if it wasn't true, then I think there's more of a chance the judge would have granted his motion to withdraw. If it wasn't true, or I would say if this lawyer didn't have some of the past knocks that he has, maybe we would have a different context. But under this context, I think at least some of it's true. I don't think the judge usually doesn't have to order a criminal defense lawyer to meet with his client prior to a pretrial date 2 weeks before the actual murder trial is going to start. So that's trouble. Jennifer D says karma. I get it. I get it. And I'm not saying that, that she's going to win or lose because of this, but this is tough. And it's absolutely an appellate issue. Tori, I don't like what she did, but Sarah deserves an aggressive defense and a lion who will work for her in her corner. That's the judicial system I love. That's the judicial system I love and protect. Thank you, Peter, for being here on vacay. Absolutely. That's our judicial system. And it has to be that way. Lady Cat Austin said, I'm new here, as you all can see. There have been other videos on this case. We've gone through the interrogations. We went through this lawyer's motion to withdraw. So for context, you can check it out. But this is the suitcase zip-up murder trial that's happening in Florida. January 30th is the trial date when it starts. So if you're interested, please subscribe and hit that reminder bell and make sure you're here for these videos. Melistasi, question, Peter, what do you think is a reasonable amount of communication for her situation? So here's what I'll say. If this trial was a year away, once a month is probably enough to keep her updated on her case. But as we're coming now to the final, I'll just tell you, my clients, the final month when we're prepping for trial, I'm talking to them every couple days, literally every couple days, talking through things, getting updates, talking about the witnesses, the testimony, the evidence, the medical records, whatever it may be, every couple days. They're not in custody though, so it's a little different. I think personally, at the very least, an update after every court hearing or court filing in her case, especially important ones. And additionally, weekly meetings, weekly updates. Now, before the pretrial, you should have a long meeting explaining what's going to happen at the pretrial. Then the pretrial happens. I would say the following week, multiple times that week, should you talk to your client before their murder trial starts. During the trial as well, we're with our client and talking to our client all day, every day. Alyssa Hendry, do we know why the other attorneys were allowed to be removed from the case? Can the bar do anything about this current lawyer? Limited contact. The bar can do anything when they think a lawyer does something wrong. I don't want to really get into, bar discipline here for this lawyer. I don't want to be, trying to get this lawyer disciplined by the bar or anything like that. And I'm not saying that's what you're doing at all, Alyssa. The bar can do something. The answer is yes. They absolutely can reprimand lawyers for limited contact. I don't know that it's risen to this level in this case. I do wish we would have gone through kind of all the other motions to withdraw. I did not. Maybe one day if I have time, I can go through and look at all those. But I do know that all those other lawyers were allowed to get off the case. And now that's one thing that I don't necessarily know if I fully believe Sarah Boone, that it wasn't her choice or wasn't her fault that any of those other lawyers were booted or changed. That's probably not fully true. Yeah. Winter Walker says the majority of us are agreeing. I agree. So we're all on the same page there, that she deserves legal counsel. All right. Let's get back to the letter. The problem is that my constitutional rights are incorrectly being waived without my knowledge or permission. I've never signed anything nor verbalized the idea that I wish to waive my appearance to any of my court dates. I want to be present for all dates. We saw this with Darryl Brooks. She absolutely has this right. She should be there. We don't want to blow people's constitutional rights. We want them to be present, especially for their court dates. I want to be present for all dates going forward, please, regardless of the significance. All are significant to me, since my attorney fails to relay any information in any way. If he's not going to, then I must myself and for myself. As always, my entire file. What else can I do? Who else can I seek help from? I have you and God. Judge Wooten, if I do have an attorney, where is he? There's so much to do all over my case. Hopefully the right way this time. Off to a rocky start where I wonder how more extended my time will be on top of all the time, soon to be 36 months, 3 years already. Is this how the justice system really works? Am I being penalized for wanting to be fully involved in everything in my case and intelligent enough to know how my case is being handled is unjust from my point of view, disastrous considering I'm still sitting here in Orange County Jail, counting the days and praying my sixth attorney contacts me and we can move forward, finally coming to an end of this seemingly endless debacle. You would think, considering the circus show my case is being made out to be with all the hype, sensationalism, and publicity, I received a letter all the way from across the pond, England, the other day. It would be being handled more professional and better. I learn something new every day about the facts and events and outcomes in my case from all the inmates and officers as well. I wonder if they might know where my attorney is. Bottom line, please understand, I don't want to be here any longer. I don't want to be hindered any longer in getting just to the starting line again. I don't want to be suppressed in being heard finally, truthfully, and correctly. So when Judge Wooten, when will I hear from my attorney or you, please, just with some sort of response other than a copy of my letters I keep sending, which I already have. All right, before we get to those dates, this is clear. She doesn't want this attorney gone. It seems like she doesn't want to delay her case again, which is also important because the judge doesn't want to delay her case. Justice doesn't want to delay her case. The victims' families don't want to delay her case. Everybody wants this case to go except for Frank Bankowitz at this point because obviously he does not want to represent her. I'm not saying he wants to continue the case or delay it. He doesn't want to represent her. I also thought it was a nice little wink for her to say, well, because I'm so intelligent and can understand my case, maybe this is different. But what we don't want and what appellate courts hate to see is someone whose constitutional rights are being trampled on, who's not allowed to be being involved in their case, who doesn't have counsel, which they have an absolute right to, not an absolute right, but close to an absolute right to. She's not asking to represent herself. We can't force her to represent herself. Those are issues. Those are major issues. People should be telling her what's going on. Bodie, he's wanting to be fired. Absolutely, you hit the nail on the head. In the meantime, it's my understanding the following documents have been filed in my case. The appointment of Frank Bankowitz, my attorney, is MIA. So we go through in July, he was appointed, pretrial order, pretrial canceled, notice of unavailability by the state, correspondence, notice of appearance for what? 3 years ago, she entered the not guilty plea, waiver of appearance, which she didn't sign or agree to, which is a major problem. Compensation for what? What has he been doing? That's fair for her to know. Is he saying he's meeting with me when he's not? That's the other thing. We can know if these conversations are true. Is he getting compensated for them? Substituting conflict counsel. Who is my attorney? She's trying to figure that out. It is confusing to a criminal defendant who sees these docket entries and doesn't have somebody to explain them to them. That's it. In almost 4 months, I've been a client of Mr. Bankowitz, and this is the only progress. What's next? Where are my copies of everything filed ever? This is one way I can have some idea of what's happening. And please remember, I have no access to a computer nor any reliable copies. I'm trying to come up with any solution possible to keep me, the other party in this case, informed and updated. This also is a part of the court's responsibility. I would especially think, knowing I've not heard from my attorney in any way for 11 weeks, I want to be included. As always, I thank you for your time and understanding. Please help however you are able. I am not helpless. I am ready to get this show on the road and to hear from someone other than myself asking the same question over and over again. What's going on in my case? Or how many more pens will I exhaust asking? That's a little dramatic. Grateful and patiently waiting. I await your response, Sarah Boone. So that's what she has to say. And she does not want to delay this case. She wants to get this show on the road. Yeah, Gebel, I'm not saying feel sorry for her personally. I'm saying we need to make sure this is done right. John asks the question, right? The ultimate question. If she is not represented or misses her court dates, can that open the door for an appeal? Attorneys need to show to prevent this, right? Yes. This could absolutely open up an issue for appeal. If she shows up for trial and stuff's happening, she's like, nobody told me about this, and it was filed or done, that could absolutely be issues, and I wouldn't put it past her to try to do something like that. I really wouldn't. Adam Ace asked the same thing. Would hate to see her get away because of a technicality. And just one, everybody on the same page, ineffective assistance of counsel appeal coming right up. And that's one of the major things at the end of the day. One of the major issues at the end of the day is this going to be an appellate issue? Is she going to win on appeal because of this? And that's one of the reasons, right? That's one of the reasons behind your rights and people's rights as criminal defendants. We want this done right. And if this is done right and she gets convicted, then we don't have to worry about an appellate issue. We don't have to worry about doing this again. We don't have to worry about justice delayed. But if it's not done right, that could create an issue. Ariana saying, I wonder if she will take the stand. The state will probably rip her. We'll see. Jane Smith says she predicts she will win on the appeal. This is a major issue when we talk about the right to counsel, the right to effective counsel, the right to a counsel that tries, not a counsel that wins, not the best counsel in the world, not the best counsel money can buy. We have public defenders, we have court-appointed lawyers, tax-paying dollars that pay for lawyers, literally for people who can't pay for themselves. Sydney, 2,000 people in here. Hit that like button and subscribe. Please do, people, if you haven't already. This is going to be an interesting case, and it's upon us. In about 3 weeks, we've got the pretrial. And then 2 weeks after that, the trial is starting. And it's going to be a banger. It's going to be interesting. But there's one other question I want to answer here as we put a Zom super sticker up on the feed. Will this cause a delay? Judge doesn't want to delay. Prosecutors don't want to delay. Sarah Boone doesn't want to delay. The victims don't want to delay. But will this cause a delay nonetheless? And the answer is, unfortunately, it really could. If he says now, I thought you were going to let me withdraw, Judge. You didn't let me withdraw. I haven't had time to work on the case. The holidays, my back hurts, whatever it may be, conflicts from the state, whatever it may be. I have not had enough time to prepare. We need a continuance. And in that case, the judge will probably have to continue this case. If he is admitting he is not ready, then they're probably going to have to continue the case. But this was a really interesting one to me today, and tons of people have had questions about this case. Real quick before we sign off, the Idaho professor and TikToker, that lawsuit that we did a big video on, I have heard reports that the Moscow police have totally ruled out the Idaho professor as a suspect in the crime, which again helps her defamation case, hurts the case for the TikToker. So we'll see what happens there. So lastly, I want to say thank you for everybody that has joined the lives while we're on vacation. I told you the times are going to be sporadic. We're going to try to do a couple more while we're here. The trial is January 30th, 2023, Gabrielle. So it's coming soon. I appreciate everybody joining these random times live, but this was fun. A ton of people were here. That's awesome. Hit that like button before you bounce. And subscribe if you haven't already, and tell anybody you know that's interested in this case to jump on here and check it out, and get in the comments and let us know what they think and get the questions going. I appreciate all you so much. This was fun. Until next time, I'm out of here. Over under 85 today. What do you guys think? Let me know on Instagram or on Twitter.